Good afternoon. It's my pleasure to welcome you to this important panel on the last day of the CPDP, and we are here to discuss the policy and regulatory cooperation among data protection authorities in the age of AI. I'm sure over the last 3 days you talked a lot and you are participated in many discussions related to AI regulations, the challenges it poses, as well as immense opportunities. And probably there was an emphasis also on the increasing role of the data protection authorities in regulating and supervising the AI. And here today we will be speaking from the data protection authorities' perspective about their roles at the national level as supervisors they could play, but we will more specifically speak about the collaboration and cooperation and the role that data protection authorities could play in global efforts, regulating, supervising AI systems and ensuring that innovation and privacy can strive together, and there is a balanced approach that ensures the future-facing and forward-looking approach, which is shared and common. But at the same time, we'll be also discussing the best practices and challenges that data protection authorities face within their own jurisdictions. And we will be also discussing the good practices of cooperation as well as challenges that could be used to make cooperation in this transformative age more agile, and what lessons we could learn from the previous experiences. We are very fortunate to be joined by a distinguished panel of experts from various jurisdictions and regulatory environments, and each bring unique perspective on what cooperation looks like in practice and how we can build more agile models of collaboration to meet the demand of this transformative era. We have 3 speakers at this panel discussion. Let me introduce Ms. Louisa Klingwell. She is a Deputy Head of Unit of International Affairs and Data Flows at DigiJust European Commission. We will be joined online by Ms. Beatriz de Anchonera, Director of Argentinian Data Protection Authority, but also Beatriz is a President of Convention 108 Committee and very active member of Ibero-American network of the DPA, so she will be speaking about her own national, let's say, practices, but maybe we'll ask her to speak also on behalf of the network, as well as consultative committee. And we have Mr. Declan McDowell-Naylor, Principal Policy Advisor, AI policy in particular, at the Information Commissioner's Office, United Kingdom. With this, let me open the floor and give our panelists the opportunity to make their introductory remarks. Louisa, probably you will be first to address, and then we will ask Beatrice to join.
So thank you very much. I hope you can hear me. It's a pleasure to be here and also very humbling. I know that I am together with a lot of experts in this area. And of course, the CPDP has long been this flagship event on data protection and privacy in Brussels. But it has also grown to a place of discussions far beyond the EU, and of course there is a network effect in all of you being here today as well. And we see that many of the sessions in this year's program span far beyond Europe and concern data flow discussions relating to Japan, Latin America, Africa, just to name a couple of examples. And of course, these cross-regional discussions are really essential because we are all, at the end of the day, confronted with very similar policy questions and challenges. Also, our policy and regulatory frameworks don't exist in isolation. This is, of course, inherent in the whole idea of data and data flows. So more than ever, international cooperation and collaboration will be important to address these common challenges. At the European Commission, we're working on privacy and data flows with more countries and regions than we have done before. And this is, of course, incredibly positive. We do so, for instance, when we negotiate mutual advocacy decisions. We have a number of ones that are already concluded, like Korea, Japan, but we are also working on negotiating new decisions with countries like Brazil and Kenya. But the work that we do on advocacy decision goes beyond this traditional bilateral and, yeah, of course, as to pick up from the previous session, unilateral work to also increasingly recognize the network effect of this group of countries that we have advocacy decisions with. And promoting the multiplier effect is the key objective of the recently established advocacy network, which was launched last year with 15 international partners. And we hope, of course, that this membership will grow. Through this network, we regularly meet with representatives from governments and regulators from the 15 jurisdictions that all have the advocacy decisions in place. And we discuss common questions that we face and opportunities and learn from each other's experience. This includes, for instance, questions on how to address common challenges like impact of data brokers, how to better support SME in complying with data protection rules, and of course, the intersection between AI and data protection is very often a theme that comes into these discussions. We have also seen clear potential of regional networks of data protection authorities to join forces to foster convergence through concrete cooperation on, for instance, guidance documents, common compliance tool and enforcement, as in the Global Privacy Assembly, but also beyond this. We very much welcome the increasing cooperation between regional networks themselves. After a first meeting in Morocco, this network of the networks met the second time a few weeks ago in Brasilia. And it gathered so the European Data Protection Board, the African Network, the Ibero-American networks, as well as the Asia-Pacific networks of privacy authorities. And the European Commission, of course, actively participated in these discussions and strongly support these efforts. And at both of these meetings, cooperation on AI was identified as an area for dialogue in the future. With the rapid development and deployment of new technologies, it's not only helpful but necessary and essential for policymakers to address these questions and the impact that it has elsewhere. Of course, there's no artificial intelligence without data, so there will be no responsible deployment of AI without a core role of data protection authorities. And this, of course, puts significant responsibilities on these authorities to ensure that privacy rights continue to be protected, and in this very diversified regulatory landscape that we see now with legislation that is closely related to data protection regulation. At the Commission, we have always considered international cooperation as a need. It brings clear benefits and can help us to find more consistency in our rulemaking. And of course, these new and emerging technologies make this even more urgent. We need to work collectively for solutions to advance our common goals, to have high standards of data protection. And of course, many of the fora that are represented in the panel today, from the Council of Europe Committee on the Convention 108, the Global Privacy Assembly, the individual DPAs, and policymakers have a very key role to play in this. And we look forward to continue working with all of you to advance on this goal and to address these challenges together. Thank you.
Thank you very much. We'll be digging deep into the collaboration and the role of many actors, global actors. But before that, let me invite now Beatrice to make her introductory remarks. And as I mentioned, you can also share your perspectives on behalf of your own authority, Argentinian DPA, but also please feel free to speak about the experiences and discussions at the level of the Council of Europe as well as Ibero-American Network. Please, Beatrice, floor is yours.
Yes. Well, good morning. You can hear me okay?
Yes, we do. Thank you.
Well, good morning from Argentina and good afternoon in Brussels. So thank you very much, Tamar, and thank you, Luisa and Declan. Very honored to share this panel with you. When I first read the title of this panel, I started thinking how to frame the relationship between these three key elements: DPAs, AI, and cooperation. And of course, in the first place, artificial intelligence is today our shared reality, our shared scenario. It is not just a technical phenomenon, it's a deeply political one. And it's one that is reshaping our societies. It's reshaping the distribution of power, the allocation of resources, and the way we must address data governance. And in this changing world, when we talk about rights, we must point out that they are constantly evolving, driven by exponential technology changes. This means that we must constantly adjust our lens and look at the bigger picture with new tools and perspectives. Of course, I'm giving the perspective today from Argentina, from the Global South. And I think that we have good news. It's that we have a strong foundation. The evolving nature of data protection laws and regulations is particularly relevant today, as it gives a meaningful way to answer the fast-moving developments in AI. I think that DPAs have the ability to shape the discussion, to identify both the risk and the opportunities, and act as key drivers of responsible human-centered innovation. I think that DPAs have the vision and can put together a national strategy with international standards in our changing world. And that is why I precisely believe that cooperation among data protection authorities is not only necessary, but it is strategic. So I want to focus my intervention as how Argentina, as a DPA, cooperates with other authorities in the European Commission Adequacy Network that Luisa just mentioned, in the Convention 108 that I'm honored to chair for 2 years now, in the GPA, and in the Ibero-American Network, no? And this role that Argentina has happens because Argentina has a long-standing and strong commitment to multilateral international relationship in privacy issues, among others, no, to advance in a global level cooperation. Having a data protection law since the year 2000, it was the first Latin American country to have a data protection law. Argentina has made considerable changes in its domestic legislation, considering the ratification of Convention 108 Plus and aligning key definitions with international standards, enlarging the definition of sensitive data, introducing new data subject rights and accountability, requirements and obligations for controllers, notably in the case of data breach, and also the right not to be subject of automaticized decisions. In other words, international standards has served as a concrete way of upgrading our legislation beyond our domestic context. And these international standards, at their result, is a product of the international cooperation. So going to the European Commission Adequacy Network, we can say we have the adequacy since 2003, and we have this revalidation of adequacy in 2024. Argentina is a safe country for the personal data transfers from the European countries. And this has allowed us to sit in a cooperation working table with another 14 countries, including, for example, the United States, Japan, New Zealand, and to develop multilateral cooperation. We must build forward into this network effects for data flows, for example. Undoubtedly, promoting this free flow of data between adequate countries broadens the opportunities for international trade and technological development. Moving forward to develop concrete measurement of this economic impact of adequacy decisions would contribute to making the benefits of such frameworks more visible and strategically actionable. We can say that this cooperation between adequate countries is developing beyond the Brussels effects. Today, the protection of privacy and personal data in a digital age is not only an European topic, it is an international multilateral issue that concerns all of us. It's a strategic issue in global geopolitics changes. So now turning to the Council of Europe and Convention 108. Turning to Argentina's role in international cooperation and my role as chair of the Committee of Convention 108 of the Council of Europe, we are working hard to support the entry into force of Convention 108+. We are very pleased that early this year, March, to be more precise, we received the ratifications from 2 Council of Europe member states, Greece and Monaco, which brings the number of ratifying countries to this instrument. We are now 33. 5 more ratifications are needed to reach the necessary numbers for Convention 108+ to enter into force. In this regards, Convention 108+ can also create further opportunities and synergies for cooperation in the field of data protection and AI, and other types of new digital technologies, such as neurosciences, LLMs, blockchain technology. To facilitate this, the Council of Europe is considering making available a practical tool for all participant data protection authorities by launching a 24/7 contact and cooperation platform in transborder privacy cases. Today, the focus is on encouraging more countries to join this convention, which offers a global answer and serves as a common ground for addressing future challenges. So, a word on the COE new framework convention on artificial intelligence that was open to signature in Lithuania on September 2024. The Framework Convention is the first international treaty in this field and has a global vocation. It has received 16 signatures, including last week's signature by Ukraine, with signatures already obtained from the European Union, also on behalf of its 27 member states, the United Kingdom, Canada, Japan, and the United States. All G7 countries are on board. We hope that it will enter into force as soon as possible. It only requires 5 ratifications, including 3 Council of Europe member states. And I want to state that we are cooperating between 108 Committee and Artificial Intelligence Committee in the Council of Europe. So Going now to the Ibero-American network, where Argentina is part of its executive committee. I think it's a very highly relevant network for cooperation and the harmonization of interests between our countries. Through the exchange of experiences and best practices, we are making progress together in developing a situational view of our common challenges. In October 2023, Argentina adopted the standard contractor clauses of the Ibero-American Network for the protection of personal data. At our last meeting in Brasilia, as Luisa pointed out, we held the second meeting of the Network of Networks of Data Protection with representatives from Asia, Africa, Europe, and of course, Latin America. And soon in Cartagena, we are holding our annual meeting, and we will address the update of the Ibero-American standards, so necessary to be in line with the last technological developments. In this sense, it will incorporate some new categories of neurotechnologies or generative artificial intelligence through collaborative working groups among countries in the region, which will foster their adoption. We will also review our strategic plan. This document will provide a consensual roadmap for the network's strategic objectives over the next 5 years, structuring its actions around shared goals and sustainable mechanisms for interinstitutional cooperation. In addition, we are actually evaluating the creation of an Ibero-American observatory. This is a particularly promising initiative as it could serve as a dynamic repository of updated laws, principles, and standards across the region, supporting mutual recognition of adequacy and enabling strategic alignment. Finally, Argentina has a role in the DPA. We were a member of its executive committee and completed a 2-year term on the strategic subcommittee. And we are co-sponsors on the resolution on data free flow with trust, sponsored by the European Data Protection Supervisor and the Federal Data Protection Commission of Germany. Cooperation here has helped us identify clear guidelines on how to bridge the gaps between different regulatory paradigms. So just to state how we see these network effects, being part of all these networks, we can say that the network effects materialize in bringing together perspectives from different strategic stakeholders, data protection authorities, civil society, academia, and business chambers. It provides regulatory frameworks for convergence, such as the Ibero-American standard contractor clauses and the COE standard contractor clauses. It promotes, this network effect promotes the intersection between data protection, transparency, and open data, and it builds capacities, playing a key role in training and education. And finally, I think that this network effect can drive the regulation of the activities of large technological companies to make us work together, to find compliance together and enforcement. So, just to end up my intervention, the big picture from the global south is that we must also recognize that there are different data protection regimes across the world, shaped by diverse political, economic, and cultural contexts. In the global south, we face particular challenges when it comes to advancing in this field. One of the most pressing is how to bring these issues into the political agenda, how to make privacy not only a legal compliance concept, but part of a broader privacy culture of rights and democratic values. Another key challenge is institutional, to effectively enforce data protection authorities and address the complexities of artificial intelligence. We need strong and independent oversight bodies with capacity to influence public and private decision-making. We must go through the different institutional designs to address these challenges. So Cooperation among data protection authorities should not be reactive. It should be anticipatory, strategic, and inclusive. Artificial intelligence is reshaping our regulatory agendas, but it's also an opportunity to create new instruments, new governance, to reimagine how we can govern technology and human rights with human rights at the center. To follow our common goals, we need to plan together, to plan strategically and prospectively. So thank you very much. I'm still here to answer forward questions.
Thank you so much, Beatrice. Indeed, you highlighted that the cooperation is really imperative. I mean, it's not an option, it's not a wish anymore, but this is strongly needed, especially with the challenges you mentioned. But you also mentioned that there are some good news, including the developments we see at the policy and regulatory level. There are many jurisdictions with data protection laws, like the GDPR was something that shaped really the development of many legislations worldwide. There are more than 172 jurisdictions with data protection laws, more than they share the common principles. Now the same expectations are with regard to EU AI Act, and we see a lot of developments in different parts of the world concerning like AI strategies, sandboxes, some initiatives concerning draft regulations. But part of the good news for me is that over this last couple of years, also data protection authorities gained certain expertise and experience, even without specific AI-related laws. They were able to address concerns related to AI systems, and they also very closely were following the developments, technological as well as the regulatory, and one of the authorities was very active with that regard is here. So I would invite Declan to share more about the practical aspects, about the concrete cases involving AI that you had to dealt with, and then maybe like good examples of enforcement cooperation, especially, as well as lessons learned, like what could be improved. And I'm sure that there were some challenges that you faced where the cooperation and the counterparts in other jurisdiction was much needed, but you faced certain challenges. And please share like from especially like please share your insights about the enforcement cooperation, and then we'll come back to the 24/7, let's say, model that networking opportunity that Beatrice was mentioning. Please, Declan.
Thank you very much. Thank you for the introduction. If I may, I'll just run through the role, the ICO's work in AI first, just to set the scene as the others have done, and then I'll kind of dive in a little bit more into the questions. So, yes, I represent the Information Commissioner's Office, which is the data protection authority in the United Kingdom, led by our Commissioner John Edwards. We have a slightly different version of the GDPR. It's called the UK GDPR, unsurprisingly, as a result, obviously, of Brexit. So we have a slightly different a version of the law, and currently in our Parliament, we're also reforming that law to an extent as well. Happy to discuss, but just to kind of draw your attention to that, we also don't have the AI Act either, which is another thing to kind of point out to in comparison to our European counterparts. So I think the ICO clearly recognises that AI has a huge potential to transform businesses, public services, and that's for us why it's such a significant priority, and I'll tell you about some of the work that we've done. Data protection to us is essential really to realising this opportunity and ensuring that the public can have trust in AI. So many AI systems rely on the use of personal data, which gives data protection authorities, ourselves included, a very, very important role to play in the sort of general culture around AI. And as a whole economy regulator, we're also committed to ensuring that organisations can innovate and grow, but doing so in a responsible way that upholds people's rights and freedoms. So part of our role as a leading regulator in the UK doesn't just mean engaging with other DPAs across the world. It also involves collaborating with other regulators in different fields within the UK and abroad. So we are part of the Digital Regulation Collaboration Forum, which is a forum in the UK which brings together our competition regulator, our financial regulator, and our media regulator, because we recognise there's this kind of shared set of challenges, particularly in relation to AI, that we need to address. So I think that's also something that kind of applies more broadly as well there's been lots of panels here around things like the DSA and the DMA, which has been quite interesting to hear about those as well, and the intersection that those things have with data protection or the GDPR and other forms of data protection. So this is a really useful forum because it allows us to share knowledge, work together on cross-regulatory issues, and present, hopefully, a seamless service to people who come to us for advice. And I think increasingly we're seeing with the complexity of AI, not just the need for DPAs to work together, but also DPAs to work with other regulatory authorities, including internationally. In terms of challenge, I think we're going to get into challenges a little bit in a moment. The really important thing I think to emphasize for us is that AI is not a very new thing to the ICO. We have been working on these issues for well over a decade. We've had reports, etc., from a long time ago now, which have been giving practical tools to those who wanting to have regulatory certainty. And of course, the work is not finished. There's lots of work to continue to do in AI. So just last year, we completed a year-long consultation on generative AI. Hopefully some of you have seen this. It's culminated in a very detailed response setting out our analysis on how specific areas of data protection law apply to generative AI systems. We, as part of that work, actually, we engaged with the CNIL in France, had some workshops with them as part of that whole process. And I think we've also had a discussion at some point with the EDPB as well to kind of share some thoughts and learning around that whole area. So that's just one area, early area of important collaboration. I think the engagement we had with the CNIL was very fruitful. It was like a 3-hour session, so there's obviously so much to discuss. I think I pointed out as a good example of collaboration between DPAs. We also recently published a report on the consensual audits that we did with AI and recruitment providers. It's a very detailed report, has something like 300 recommendations in it. I very much recommend you have a look at that. This is another example of how we're trying to tackle the issue of AI and bring certainty around AI and data protection. Most recently as well, we also published a joint statement with one other our DRCF counterparts, the Competition and Markets Authority, where we set out how data protection and consumer law interact on the area of generative AI across issues like closed source and open source models to try and, again, kind of get to the bottom of these very complex issues. And of course, we have a regulatory sandbox. We collaborate with fellow regulators in the DRCF with the AI and Digital Hub as well. So that's our sandbox is another example of how we like to try and take a forward-thinking, kind of innovative and proactive approach. So there's many other things in the works, which I'm happy to talk to. But I'll just now talk about the international collaboration and how we think that can help us foster an environment where businesses can flourish. So I don't think ever been more important for there to be cross-regulatory collaboration between DPAs, especially as AI technologies develop, become more complex, become more embedded into society. So there's a really important point for us here about learning from other DPAs as much as possible. As I said, we've worked with the CNIL on that point. Also, a point of interest that I can't say much more about it is most recently in the government's growth strategy, we've committed to updating our guidance on international data transfers and also our transfer risk assessment tools as part of our pledge to government. There's nothing more to say about that right now, apart from that we are looking to do that. And of course, also very open, and we've signed quite a few of these recently, to memorandums of understanding with international partners to help, as I say, increase the kind of information flows between DPAs as much as possible and drive high standards of privacy and data protection. So just a couple of areas where we've worked together with other DPAs. The joint statement on data scraping that we signed within G7, complementing, I think, our regulatory interventions in the AI and scraping place of this joint statement was basically trying to set out our position, along with all the other DPAs, on how we think data protection law applies to scraping, and some of the key things that we've mentioned were publicly accessible information is still subject to data protection and privacy laws. That's something we all agreed on. That social media companies have legal obligations to protect that information from personal information from unlawful data scraping, and that mass data scraping incidents themselves can constitute data breaches. So these are some of the key things that we've laid out in that particular example. We think this is very useful. I think it's really important to have this international cooperation because it provides regulatory certainty, not just within our home jurisdiction, but obviously across borders as well. And we also felt that the principles in the data scraping joint statement were broad enough to apply across many different privacy frameworks as well, obviously taking into account that different jurisdictions have maybe slightly different interpretations of data protection, slightly different data protection laws. So again, trying to create something that can fit into lots of different data protection laws themselves. One of the, I guess, the interesting things about the that data scraping joint statement was that it was applied for us in our findings from the Clearview AI enforcement. You may be aware of this is also another example of collaboration, because as part of the investigation to that, we worked with the Australian colleagues, the Australian DPA as well. And I think that showed a good example of theory and practice when it comes to data protection law. So both try to set out how data protection law applies to something like data scraping when it comes to AI, but also in our enforcement action against Clearview AI, also demonstrating how that can work in practice. There's many, many other areas. I don't want to spend too long talking about, leave the room to questions, but that's just a very quick overview of some of the areas that we've worked in. Thank you.
Thank you very much. We'll definitely get back to you. But before, let me invite Beatrice to share, because we all acknowledge on this panel, as well as probably the audience in the room, we all agree that AI, collaboration was important for many, many years, but AI just brings the new development, the new challenges that we all acknowledge that it will be hard to deal for the single authority individually. And Beatrice has mentioned the institutional capacity building needs of especially probably the newly established DPAs, but she also mentioned the 24/7 network that now is discussed at the Council of Europe level, which seems to be for me, very practical tool, because indeed, collaboration, coming together, making joint statements and resolutions, and I'm also speaking as a former data protection commissioner, I was part of this conversation, so if something sounds critical, it's also self-critical. These are all very important, as well as like joint elaboration of the guidelines, but the practical opportunities and practical tools for the cooperation, information exchange, sometimes this is so crucial for any particular investigation you may have. So please, Beatrice, share with us your thoughts and what we could expect from the Council of Europe. Thanks again using this format also for promoting the convention and inviting parties to join and ratify the convention as soon as possible, because it seems that it will be providing for us additional practical tools which are so needed. So floor is yours. Please feel free to explore on those topics. Thank you.
Yes, thank you, Tamar. Just to share some of my thoughts, and I at this moment can't give the technical details of this this platform that we are thinking about, because it's in the design phase. But yes, I can share with you the spirit that we aim to have from the Council of Europe and from Convention 108. I think that at this stage, the committee and the Council of Europe and Convention 108 can play a key role, for convergence, and a key role in cooperation, in cross-border privacy. We can say that the TPD has advanced in the adoption of the 3 module of model contractor clauses for the transfer of personal data from parties to non-Convention 108, from parties to non-parties, and based on the expertise and the experience of similar instruments. And perhaps the spirit is to work in this convergence between the standard contractor clauses of the Ibero-American network and other instruments. And this is part of what we think about this cooperation platform in having a practical use for all the countries to put together this a common ground, in transborder privacy. I think that in this way, we are anticipating that when the Convention 108 Plus comes into force, we will need of course, an assessment tool and a practical tool for cooperation and putting together these different instruments that already exist but need to be more convergence. No, this is one of the key topics that we are working in the Council of Europe, and we want to become global. No, and that's where the discussion, the usually discussion about the Brussels effect, and I think that it is important to go beyond the Brussels effect and have more countries. In Latin America, Brazil is already an observer of Convention 108, and I think this year Ecuador, Colombia, and Peru can become new observers, and we are going to expand the network of Convention 108 to other regions in the world.
Thank you so much. Indeed, the practicalities and practical tools will be, I'm sure, further incentive apart from the protection of fundamental rights and ensuring that the convergence among the different legal frameworks. I think that the practical tools that could be available, especially in concerning the enforcement cooperation, would be another incentive, because everybody worldwide realizes the importance of collaboration and joint actions. Declan, can you also share your perspectives? And because we are, like, the panel was, discussion was structured in a way that we want also to assess the current state of cooperation and best practices, or maybe challenges that we have currently. So in a way that we analyze it also to build upon and learn what we can apply concerning the AI and the new challenges that it brings. So please feel free to share the concrete cases of successful cases where, if they were related to AI, even better, but or like your observations, what you as an authority dealing with so many cases would wish or would need when it comes to the collaboration. It could be, please feel free also to talk about more global or broader, a multilateral as well as bilateral cooperation.
Yes, of course. I have to caveat by saying I'm not from the international team in the ICA, but I do engage in certain international forums. So one of the particular ones will be the DPAs working group right now, where there's many different lots of different things going on in terms of areas of focus. I guess one of the practical challenges I think that we have dealing and engaging internationally is the limited resources that we have as regulatory authorities in the first place. So I think there's sometimes there's definitely a hard challenge where, as regulators, we need to focus our resources in the most strategic way we can, given that we don't have infinite resources. And I don't think there's a single data protection authority in the world or regulator in the world that has infinite resources. So there's a first challenge. And then I think secondly, connected to that is aligning resources with other DPAs who may have different ideas about what should be prioritized is another, I guess, a practical challenge, right? Because you do need people to work on these issues and you need people to work on these cases, and you need the information that you have in the first place as well. So without reverting back to the point around it's about knowledge sharing and everything else, I think there is another practical challenge in actually acquiring the information that you need to take an enforcement action or take some kind of action against a controller who may or may not be following the law. And I think that's a really good, strong. That's why I think that there is a strong value in these forums. You know, some people call them talking shops. I actually think they're very, very, very important in terms of lessening the workload, practically speaking, for regulators if they're able to share. There are, of course, limitations to that because not all of the information that the ICO may receive from a controller is information that we can share freely. In fact, we're actually bound by legislation to not share commercially confidential information, for example. So I guess there's a real practical challenge there as well in trying to judge to what extent are we able to share information, how far can we go with that, because obviously it enables the kind of cross-border work. And the one I would point to as a good example, I think, of collaboration in terms of, I think we're looking for in terms of enforcement, would be the Clearview case, where we worked with the Australians. We combined our resources in the way I just kind of described, and that enabled us and also them to take some action. There are details about the Clearview case that we can discuss because they're obviously it's an ongoing piece of it's an ongoing court case in the UK. We've twice now appealed the lower court to have another look at the decision. But this is an interesting case, and I think it's one that's probably hopefully at the forefront of people's minds when it comes to how we enforce or take enforcement action against AI developers, because it has all the kind of necessary ingredients. You know, you've got data scraping, you've got the fact that it's used to train an AI model, for example. So that for me would be a good example. And then, as I say, for me, it's just really important that I think there's more work involved in aligning strategic priorities between DPAs than potentially than it sounds. I think there's a lot of work to ensure that we're doing that. Thankfully, AI catches everyone's attention. But even within that, there are things that need to be prioritized. Do we look at agentic AI? Do we look at generative AI? So I think in the G7 Emerging Technologies Working Group, there is going to be a focus on agentic AI. But as I say, there's so many different facets of AI that could be focused on. And obviously, as data protection authorities, we've taken a lot of focus on generative AI recently. But that doesn't mean that another area is not looked at potentially as much. So automated decision making, for example, an area I work on a lot, is another key area. But you have to find the resources to look at all of these things at once.
Thank you. Indeed, it's it gives you more incentives to each data protection authority to prioritize, the cooperation, because you feel that you need this for particular reasons also to respond to the challenges and address the problems in your jurisdiction. And maybe, Louisa, now let's discuss the role of regional and international networks, and more importantly, like actors like European Commission, what other international organizations really could do to facilitate this strategic, and deeper collaboration, especially in the area of enforcement, but feel free to also highlight the other areas where you feel that there are opportunities and there are also desires to support.
Thank you very much. So, we obviously have the kind of established network and for us that we have already discussed, but I think that, we are trying to jump at any opportunity where we see that there is an interest to cooperate, learn, and exchange. And there, I think very often, our best role is also to be the facilitator, because, in our role, we had, for instance, an incredibly interesting meeting bringing together a number of the enlargement countries that face the daunting task now of putting in place data protection regulations that eventually will live up to the standard that they can assume the GDPR. And of course, they are also at very different levels and states of where they stand on this. And no one, of course, is better at learning and providing information and insights than those that already did it. So I think we try to be very flexible in finding all of these opportunities where we see that this mutual learning and sharing of experience can be beneficial. And we were very happy to see, recently the African network of DPAs joining up with Latin American networks to discuss data protection and in the age of AI and the sharing of that insights. And so we believe, and I would very much echo what Declan is saying, that to a large extent this is also a question of resources. We have all been sitting in whatever capacity with a blank sheet of paper and seen how long it will take first to understand the problem, the intervention logic, and what do you need to do, while if you share these experiences, even if your regulatory systems are quite different and diverse, you will always get an insight also on the substance of the matter and the problem that is facing us, which is now rapidly moving and constantly changing.
True, indeed. And probably the discussions that we had maybe provoked some questions among audience. I don't want to miss the opportunity to engage you in this discussion. Please feel free to ask questions as well as just express your own opinion. I see many researchers here, and maybe like the discussions here brought up the new topics also to research, you know, and to study. Please. 1, 2, I see it here.
Thank you. Christos Velasco, adjunct professor on cyber law at German University. It's very interesting to see how that those initiatives concerning, you know, the point of contact have it within the context of cybercrime investigations, the Budapest Cybercrime Convention. And this is a great initiative. And I really, I mean, I'm amazed that this is going to happen. The only thing is like, it would be something about like coordinating the countries, like who's going to be the appointed contact. Because we have to think that in some jurisdictions, there are different national data protection authorities that are competent at the federal, state level, municipal level. And that's an issue, no? I mean, but definitely. Another thing that actually came into my mind, and you might probably remember the days of the OECD on the Global Privacy Enforcement Network, which was this mechanism that was used within the context of the OECD for DPAs to share information among them. And it was a mechanism that was pretty useful, especially, well, information sharing, knowing about, like, you know, possible threats, things. But at the end of the day, the recourse was at the National Data Protection Agency. You know, when something wrong happened with the data, with the data of a data subject, there, I mean, but this is also, I mean, the mechanisms are there. I mean, now we'll have with this initiative. So my question to you is, for instance, now we are seeing a lot of transborder issues, especially with data breaches, where you might probably have like data subjects affected in 2 or 3 more different jurisdictions as a result of a cyber attack. So my views is, how are national data protection authorities, in particular, I would like to hear the view from the representative of UK, going to come up and resolve these issues on the best interest of the data subjects? Thank you.
Thank you. I saw also your hand. Please go ahead.
Thank you. I'm Charles Robb from the University of Edinburgh. About 15 years ago, I did some research on and published some articles on the networks of regulation in data protection. And what I found and what I was writing about was the way in which there were 2 kinds of levels. And depends what you mean by a network. And there are all kinds of networks in the formal sociological analysis of networks. There are tight ones and loose ones. There are open ones and closed ones, and so on. And at the top level, you had the International Data Protection Commissioners, who would meet once a year in formal terms and introduce declarations like the Madrid Declaration and the Montreux Declaration and so on. That was a regular quasi-institution network amongst the global data protection authorities as they were then. Below that, there were what I call the subglobal level, the Iberian, Ibero-Latin American one. There was a Central European, Eastern European one. There was one which in the UK was involved, along with Jersey and Guernsey and Isle of Man and some other places, and so on. And these were much looser. And among the issues that I thought was emerging and questions was, to what extent will networks become institutions? What does it take for a network to become institutionalized to the point where it has a secretariat, where it has a systematic way of keeping its records, which the International Data Protection Commissioners didn't have at that time? At what point do they face the public with statements and declarations and so on? Or are they simply, because of lack of resources, has been mentioned, unable to become institutionalized and therefore unable to have much clout in policy circles in countries and also internationally and globally. So I wonder whether what we are observing now with regard to AI will remain as a kind of looser network which may do great work but will not be able to have much clout, partially because of the resources issues, partly because maybe of disagreements in the different countries in a competitive market situation with big tech firms. So that's a whole bunch of stuff which I think history is important in this, and also trying to anticipate the future where you may have either the decline of networks or the moving on to an institutionalized position. Thank you.
Thank you. And we have one more. Please, go ahead.
Thank you very much. I'm Aaron Martin from the University of Virginia, and it's almost as though Charles was reading my mind, because my question is essentially kind of an elaboration of your final point, which is kind of bringing the conversation back to artificial intelligence and the challenges that it presents. Are there any specifics of AI, whether that's technological, commercial, competitive, or geopolitical, that you think might create either sort of impediments to cooperation among DPAs or potentially opportunities, right, to flip it more optimistically? I don't have an answer to that question. I'm generally interested, so if you have any insights, that would be helpful. Thank you.
We may have the second round as well, but let's use the opportunity now to discuss those three questions. So, like, you are free to intervene, and you can pick the questions you want to respond. But probably about the 24/7 network, and you rightly mentioned, it's like not novelty. At the Budapest Convention, the similar network exists, and like probably I'll let Beatrice to respond about the practical aspects, but also like please feel free to join in. I myself I'll add a couple of points then from my side. So let's do in order. Please, Beatrice.
Okay, I missed a little bit of the first question. I wanted to build up to the second one. Of course, at the end of the day, like having institution or networks going into institutions, it's clearly it's jumping, and I think it's a resource matter. At the end of the day, Declan pointed out, it's a program of resources, but I think it's also a program of leadership and politics. I think that to build up institutions, there has to be a clear conflict, a clear problem, and the institution is the answer to it. So if the problem doesn't go into the political agenda, I think that it's very difficult that institutions can be built up. And the other question is, do we want to be a formal institution, or we prefer like the networks that have perhaps a more informal way of going through the different topics and the cooperations? Because also for the DPAs, that we are not part of the government, because we are autonomous agencies, sometimes it's difficult to build up in very strong institutions. Perhaps in some ways we can still discuss, we can still discuss in a network level. And I think that the network effect, it's a good one. Of course, we can build up in institutions, and that is also, it can be an objective, but well, I will stop here.
Thank you, very, very thoughtful indeed. Do you want to?
Yeah, I think I would kind of agree with Beatrice on quite a lot of that in terms of questioning the premise of whether we need or would like institutions, because there are benefits on both sides, of course, but the thing with institutions is you have to build them, which can take time and resources. And they're a more rigid kind of form of governance, right? If you have a specific institution that deals with a specific issue, it comes with its own kind of terms of services, if you like. You have to govern this institution in a certain way, and it has to adhere to certain ways of doing things, and it, as Beatrice was saying, it needs to be guided towards a particular problem. And I think precisely the point I think many of us have been trying to make is actually what we have in front of us when we're dealing with AI in particular is a very febrile and dynamic and unpredictable set of problems that we can't necessarily anticipate, although we try our best. And that networks are probably, I would suggest, maybe the most efficient way of dealing with that, because networks are moldable and you can change them and you can take things away and put things together, and that allows yourself to prioritize your resources and also work flexibly across different issues. And I think I would fold that into responding to the question here around what are the kind of opportunities and also the challenges with AI. I'd say there's two sides to the same coin really with AI, particularly generative AI, is that by nature this technology involves processing in many different jurisdictions. If you just take web scraping for an example, right, that's going to involve web scraping across many different jurisdictions, and also these tools get deployed in many different jurisdictions as well. So on the one hand, yes, that's I guess that creates the ground for DPAs and other authorities to work together, because they will be seeing a similar set of issues or opportunities even, because not all data protection doesn't necessarily need to be about enforcement and things being bad. Actually, we don't think that regulation has to be adversarial at all in many cases. We like to see outcomes as opposed to, we're much more focused on outcomes of regulation as opposed to the process of regulation. So if things like joint statements can anticipate and proactively prevent harm from occurring or non-compliance from occurring, then that's great. But of course, the enforcement powers also exist for a reason, which then goes to the point around why that's challenging, because precisely the same point, you have lots of things happening in lots of different places. Who's the lead authority? Where does where are we judging the most harm to be taking place, etc. And then working together becomes challenging, but as we've seen can be achieved, which then, to go full circle, I think is just another really kind of endorsement of the benefit of having networks. So our position, for example, in the UK on the question of whether we need another AI, like we need a fixed AI regulator in the UK, we've been consistently saying we don't think so. We think that the various kind of remits that different data protection authorities, different regulatory authorities have in the UK is sufficient for us to regulate AI, because again, we can be flexible, work together in a kind of network formation, and that there's no real need based on that basis then to create a separate institution. So hopefully covering a few points off there.
Sure.
To yourself.
Indeed, and then assessing why some practices were not that successful, I think it also comes to the resources, because compared, for example, to the Budapest Convention and the network, obviously it was law enforcement authorities who were well-resourced and interested in swift sharing of the information, while at the data protection level, you had many data protection authorities not well-resourced to invest enough and allocate sufficient resources. But now I think that with increased transborder data flows, as well as the challenges like AI, I think that the understanding of the importance of this collaboration is increasing, and I think that more capacity building is required to enable them first to understand the importance and then allocate sufficient resources, and experience sharing would be critical indeed, especially with the opportunity of developing 24/7. You have to ensure that it works also 24/7, because information, when it comes to the as Declan mentioned, information sharing or about the regulatory frameworks or particular evidences, it should be done through the secure channels, obviously, and it should be very quick and efficient, and especially it shouldn't compromise and undermine the goal that we have effective investigation and then enforcement. That's why, there are good practices and that we can share, and probably that will be the opportunities for us not to make the same mistakes, but learn on them and invest much more in improved, let's say, practices. Louisa, do you want to?
Yeah, no, but maybe to echo what I believe is been the message from the other speakers as well, that, I mean, of course, when it comes to networks, I mean, there's an advantage to a closer network that is more institutionalized. It could potentially be more efficient, but it also puts up barriers to entry. And maybe we need to look at this in a kind of quite dynamic way. I mean, there could be concentric circles of networks depending on the maturity level. But I think it's also maybe important that everyone at their level and where they sit in this ecosystem maybe look at, I mean, what are the irritants to networking and such cooperation? And I mean, looking at the last year's GDPR report, I mean, this is where we, from the side of the European Commission, announced that we intend to mandate enforcement agreements for cooperation to ensure that our regulators are equipped with the tools to facilitate this more concrete enforcement on the ground. So, yeah, I think it's very difficult to give a single response to this, but that we need to remain agile. Yeah.
Okay, thank you. I wanted to finish before the bell rings, but
I do love that bell. I think it's a very nice touch.
Indeed, I think that concerning like institutional, I think the first thing we have to maximize the benefits of all existing platforms and networks and rethink how to use them more effectively in this very transformative age. And then for example, I had the privilege to attend some discussions at the Ibero-American Network. Then I also actively observed the development of African network. And the working group methods, I think that they're very efficient because they well fit under the current structures, and they're very thematic, very focused, and they can bring the relevant actors to discuss the challenges and to address jointly, and it's very flexible. I think we see, at least I observing the developments, I see the growing, let's say, trend, which could be very flexible, let's say, and useful to address the challenges. So probably this is something we could observe further. And then there are obviously established platforms with Secretariat, including Global Privacy Assembly and these annual meetings. And there are also subgroups and thematic working groups where you see the operation, and then there is an ownership from the commitment from the authorities as well. Somebody runs the show, and others are there to help. I think that there are plenty of opportunities to maximize the benefits of the existing ones and think critically how we can develop things further. So basically, for me, this discussion really proved, once again, the importance that we have to think more about the regulatory collaboration, and we also a shared commitment to upholding fundamental rights in this very critical period where we are all part of this transformation and where we all have our roles in transformation. Let's continue building bridges across jurisdiction or align our approaches and ensure that we can maximize the benefits that we have, and also face challenges and discuss them critically and address them as well by joining our forces. So that was my takeaway. I hope you enjoyed this discussion, and thanks again for our panelists. Beatrice, thank you so much for joining online and sharing your perspectives, wearing different hats. It was really interesting for us as well. Thank you so much, and thanks for staying with us this late afternoon. I'm waiting for the guy to come and ring the bell, but maybe we can finish the